All right, thank you. All right, good evening, everyone. For the record, Senator Nick Charles, Chair for the Task Force to Study Fiduciary Adjudication in Maryland. And today's date is Monday, December 1st, 2025, and the time is now 6 p.m. I'm going to bring this task force meeting to order. We are going to be having our public hearing today, and we have broken it out into two panels. We have panel one, which has 4 individuals, and then we have panel two that has 5 individuals. We're going to keep folks in the waiting room until they are called to testify. For your Zoom name, when your Zoom name, it should ensure that it's a username that clearly reflects your first and your last name and the organization you represent. For your audio and video, once admitted, please exit your YouTube live if you're watching there to avoid feedback, and mute your microphone until recognized by myself. For your camera, you must have your camera on during your testimony, so you cannot designate someone else to take your slot. And finally, driving. You may not participate while you're driving. So if you are in the car right now and you will be speaking, I need you to pull over and be safe because that is of the most important concern. And so with that being said, we are going to start off with our panel. Every person will get 2 minutes. And after the entire full panel has spoken and had their 2 minutes to say what they need to say, we will open it up to the members of the task force to ask questions. And I'll ask that the task force members be very precise with your questions, and also for the all of the panel participants, I ask that you be very specific and stay on topic with the issue at hand. And don't throw any bombs at anybody. Don't throw any jabs. Let's just keep it focused on the actual role of this task force so that we can have very specific information as we close out what we're needing to close out. So with that being said, I'm going to open up panel one, which is Elizabeth Fitch, Chris Manners, Lisa Yates is not going to be with us today, Alexis Burrow Road, and Judge Lewin Scott Garrett. I want to open up panel one, which is Elizabeth Fitch, Chris Manners.
You need to turn off your live stream.
Is not going to be.
So if you are joining us from the public and you were watching us live stream, please exit out of the YouTube. You cannot have it on and be testifying at the same time. You get the feedback.
I am not using YouTube. However, I unfortunately cannot get my camera to operate.
Chair,
Go ahead, Holly.
Chair, it's up to you. If you would like him to testify, if you can't get his camera working, I defer to you. But have you tried turning it? Have you tried at the top, Chris, trying to turn it on?
Yes.
Okay.
Chris, could you log out and log back in?
I can certainly try.
All right, we'll wait. We'll let you're second. We'll put you down towards the bottom, but we'll let Elizabeth Fitch start off, and then you can kind of try to get back on here. We really want to have everybody on camera.
Mr. Chair, I'm here, but I'm going to be off camera.
I see. Delegate.
Yeah, no one wants to watch me eat, so that's why I'm going to be off camera.
All right.
Mr. Chair, if you want, Chris Manners can use my computer while he testifies.
Okay, he's in the office with you?
Yes, he is.
Okay. All right. So let's start with Elizabeth, and that's fine, Mary. We can, Ms. Rowe, we can make accommodations for that.
Thank you.
Yeah, I'll turn on the timer for 2 minutes. You should hear a little beep, but
Can you remove Delegate Kaufman from being at the top? on my screen, he is listed. He's pinned to the top.
Oh. Uh-oh.
Chair,
And
I think that might be on your computer. Is there a way for you to exit? Because I don't have them at the top of
I don't
mine.
have them either at the top.
okay. I guess it's the multi speakers. All right. Here we go. It was the multi speaker. It was me. Blame it on my computer. All right, let's go ahead and get it started. For Miss Elizabeth Fitch, Joe, if you can set the timer for 2 minutes.
Okay.
Thank you, Chair, Senator Charles, and members of the task force, especially Chris West, who sponsored the bill to make this task force possible. My name is Elizabeth Fitch. In 2018, I was elected to the Orphans Court in Howard County. In 2022, I was reelected, but in that same year, as this task force has learned, my court was abolished. So Howard County is one of the jurisdictions that no longer has a dedicated probate judge. One of the circuit court judges sits and hears probate once a week at 1 o'clock. When I first left the bench, I worked at Sims Bone and Sims with Senator West, had a lovely time there and had the pleasure of getting to know him. Earlier this year, I moved from Sims to Whiteford, Taylor, and Preston, where I am a partner that works out of our Howard County office, and I chair the firm's regional trust and estates group. I've attended all of these meetings. Me and like 6 curious souls have watched all of your meetings. And, you know, just been surprised to learn a couple things. You know, when you pay as much attention to these things as I do, it's surprising when I learn something new. I had no idea that the registers have no minimum requirement, no training. I don't really know if they're supervised, who supervised them. But I think what the real intention of this task force was to take a good hard look at fiduciary adjudication and see what Maryland can do better. And I had hoped that we would look more at what other states do. I'm a member of the National College of Probate Judges. We meet twice a year for a week each time. And we talk about big issues and how different jurisdictions handle them. And I've learned from that experience that most of the probate courts in the country have a much broader jurisdiction than we have here in Maryland, and that seems to work better. Also, those judges are almost always attorneys, each of them handling their own dockets, similar to how we have in PG County, Baltimore City, and Baltimore
Fitch?
County.
Yeah,
Mhm.
the time is up.
The time is up. So
Oh, wow.
everybody gets 2 minutes.
That was quick.
Yep.
Okay.
Yep. And so I know one of your colleagues will probably ask you some questions
Sure.
later on into this.
Okay, happy to answer questions.
Mr. Manners?
All right.
And for all intents and purposes, he is not Mary Rowe. This is Chris Manners, everyone.
Greetings. Thank you, Mr. Chair, and thank you, members of the task force. My name is Chris Manners. I am the Chief Deputy for the Frederick County Register of Wills Office and the Acting Clerk for the court. The process that I've been involved with has been supporting the court largely by means of my position with Virginia Pfeiffer initially, who considered me a gift to the court. I have 15 years of experience with 5 different panels. The majority of them have been lay people, and they have all been very decent, hardworking, service-oriented individuals. The registrar's office, however, has been in the position and required to prop up the Orphans Court for Frederick County, in as much as sometimes the lay judges do not have the necessary and requisite information at their hands to go ahead and assist the public with making informed decisions in the process. Without the structures and the assistance rendered by the Register of Wills, the court would be at best marginally functional. The member judges have varied from highly competent and well-educated to, in some unfortunate circumstances, incompetent. and a couple have resigned from the bench due to dementia. We have had issues with judicial disabilities, removing a judge. And although I'm very, very fond of some of our current and former judges, they simply are not a good substitute for a fully vetted judge, as in circuit court judges. The level of assistance required by the panels has been excessive. When I started, my job for the court occupied about 15% of my time.
As time's up, sorry.
That's
You
okay.
could finish your sentence, sir.
I was just meaning to say, without a change in the caseload or circumstance, my increased workload is now up to about 40% of my time.
All right,
And,
thank you.
I'm
Thank
not
you.
an employee, but thank you.
All right. Next up is Alexis Borough Road.
Hi. Hi, everyone. I'm Alexis Burrell Rohde. I'm the Register of Wills for Baltimore County. I'm also the current president of the Register of Wills Association. Having said that, I am here in my individual capacity. I was not selected to represent the registers in the task force. So take everything that I'm saying as my own personal opinion about this. I'm a career estates and trust attorney. I practiced for 10 years at Oberkaler, where I devoted 100% of my working hours in estates practice. I then represented all the registers and orphans courts around the state with the Office of the Attorney General. I had occasion then to visit majority of the courts and registers offices around the state. So I devoted my life's work to probate matters, and that sort of thing. 2 minutes is really short. My two main points is I believe that orphans court judges should be attorneys licensed to practice and in good standing with the Maryland bar. I do also believe that the system should be the same around the state. Because some of the counties in the state are quite small and there are very few barred attorneys. For example, Somerset County, 8 barred attorneys. One is serving as the circuit court judge, one is the state's attorney. And so in an effort to have uniformity, I do believe that the only way to really do that is to have the orphans court be a specialized part of the circuit court. I'm pretty agnostic about that in general, but I feel like the only way we can have uniformity truly in some of these really small jurisdictions with very few licensed attorneys is to have that system. I'm basically agnostic as long as orphans court judge it. Okay, my time's up, but I have a ton of other points, but 2 minutes is very short.
I'm sure that your colleagues will ask those questions to you. So thank you, Ms. Rohde. And next we have Judge Lewin Scott Garrett.
I don't believe Judge Garrett is with us, and I don't see them in the waiting room.
And so no Lisa Yates and no Judge Garrett?
No, sir.
Okay.
Do you want us to text Judge Garrett and see if he's having any issues, and I can report
could
back?
you?
Yeah. Mm-hmm.
Chair, would you like to start with questions? And if I see him in the waiting room, I'll let him in.
Yeah, I think that's fair. Let's go ahead and we'll open it up for questions. Please utilize the hand raising tool on Zoom to be acknowledged, and please do not start speaking until you're acknowledged by the chair. All right, we'll start with you, Senator West.
Thanks. So 2 minutes is really short. It's hard. When we're in session, we generally give 3 minutes in our committee. It still seems short. 2 minutes is really short. So I want to go back to Ms. Fitch first. And you were talking about how you thought judges should be lawyers, and you think the orphans court should have broader jurisdiction. Did you have any other suggestions for us that you could add at this point? You're muted, I'm afraid. You need to unmute. Ms. Fitch, you need to unmute.
What?
Ms. Fitch?
Can we,
Not
un-
working.
can we unmute her?
Yeah, still, some reason you're muted, Ms. Fitch.
Judge Garrett says he's in the waiting room.
Thank you for
Okay.
unmuting me. And thank you to whoever muted me. I don't have a button to mute or unmute myself for some reason.
Um,
Thank you, Senator West. My opinion is, my suggestion is really very simple. You know, I don't understand why there's still a dispute over why judges should be attorneys or they shouldn't. You know, a surgeon should be a doctor, a judge should be an attorney. So I think that's pretty easily settled and a pretty easy change for the legislature to make. And then I do think that it would be nice to broaden the jurisdiction to get more of the fiduciary matters under the control of one court, to centralize, you know, the work that we do as attorneys, and to have judges that can really get into the weeds, the same way that we have family law magistrates that really become experts in family law. I would, you know, looking at the system as a whole, I would like to see some orientation training and ongoing training and supervision of the registers of wills throughout the state. I think that would be helpful. And some more, even though the attorneys would be judges, see some more educational opportunities, more funding for that. The National College of Probate Judges is a nice addition, but it's a little bit expensive. So a lot of jurisdictions can't participate.
Okay.
Thank you. And then my other question, I guess, was for Alexis Burl Road. You also seem to have a little more to say. Would you like to finish your thought for us?
Sure, and I agree with Ms. Fitch that I think expanding the jurisdiction would be really important. So to give this specialized court, whether it's a fiduciary court or a division of the circuit court, expanded jurisdiction to handle trusts and guardianships, for sure. And I just wanted to say a little more about the attorney judges thing. There are some really dedicated lay judges, and Judge Bright, I listened to all the testimony from this entire committee so far. You'd be lucky to be sitting in her court, but not everyone is Judge Bright. And when I was representing the Orphans Court at that time, I'm not going to divulge any privileged information, but as trials get more complex and there's more trials and more litigation, there was some real difficulty with rules of evidence, hearsay exceptions, that sort of thing. It's pretty challenging. It's pretty challenging for experienced litigators sometimes, and that was really a challenge for lay judges. Also, the underpinning of our fiduciary court is due process and the fundamental property rights people have in their property. And I do think 2 semesters of con law really does add a lot to adjudicating these fundamental issues for people. So at the end of the day, we really want folks in our court to have that experience brought in the bench. So I think expanding jurisdiction, I think nonpartisan elections would be great. And I know this task force isn't about registers, but I do hear the various comments, Judge Groves, Elizabeth Fitch, about additional training for registers. I think anything we can do across the board to make probate more efficient and have better quality professionals involved with that would be great. But this is about judges right now in the fiduciary court. But those are some other things.
That's great.
Yeah.
Thanks so much for your additional thoughts. And I guess, to be fair, Mr. Manners, it didn't sound like you were cut off, but if you were, do you have anything additional you'd like to tell us briefly?
The only thing that I would add, Senator, is the idea that the Orphans Court, comprised of lay people, does not have the requisite education and life experience. I'm an attorney, have been for 20-some years, have practiced exclusively in estates and trusts, and I spend a fairly sizable portion of my time with the court educating and re-educating on some basic issues involved with probate matters. And I do have a significant number of interactions with circuit court judges and other attorneys on a daily basis. And my experience is that the circuit court judges are probably the best option for any judicial choice involving probate.
Right. Thank you so much for your answers. Thank you, Mr. Charles, Senator Charles, for letting me ask these questions.
No problem, Senator West. And before Mr. Lashley, Mr. McFarland, and Judge Fisher, before we get to you guys for your questions, I just want to open it up for Judge Garrett, since he has joined us now, and allow for him to have 2 minutes. So Judge Garrett, you have 2 minutes to be very precise, to the point. We know it's not a lot of time, but you'll get time. Senator West will probably ask you questions.
Well, I appreciate it. I've been here. I'm not sure what happened, but nevertheless, I'm Judge Garrett. I'm the Chief Judge of the Baltimore City Orphans Court. I have about 50 years of experience in this matter. I have 17 years as a practicing attorney, 19 years as associate judge, and almost 12 years as the chief judge of the Orphans Court. Now, in Baltimore City, we work very close with our Register of Wills and have an excellent relationship. We have about 1,400 hearings, and that just hearings, not other matters, each year. And I'm gonna, because of time, I'm gonna just talk about a judicial review hearing. If somebody may have misappropriated money, and obviously we had to take corrective action as soon as possible. And that's akin to hearings in the other court, status hearing, motion hearing in the circuit court. I handle thousands of cases in the circuit in the district court in Maryland. One thing that always, and what is appropriate in one jurisdiction might not be appropriate in another. For instance, in the circuit court in Baltimore City, we had 35 circuit court judges. In Garrett County, they had 4. So you have to go county to county many times. Now, there are some things that I do agree with what Ms. Finch alluded to earlier. There are recommendations that could be applied across the whole state. But one thing I don't want to happen is that this committee takes too hastily an act, because there's a variety of suggestions that should be made. So anyhow, I know I'm about at 2 minutes now.
Yes, sir.
And so I'm not going, I want to go into other area, but I'm going to just rely on my written testimony that I given to
Thank you, Judge Garrett.
task force.
We truly appreciate you for showing up and participating and giving us your feedback. We have and Judge Fisher may have some good questions for you, so you can elaborate on some of the things you want to. But before we get there, Mr. Lashley.
Thank you, Mr. Chairman. This is a question for all the panelists because I'm reasonably certain that you've all dealt with lay judges at some point in each of your careers. Judge Garrett before the city converted, and the others have already talked about that. I would like, to the extent you haven't already discussed it, just the difference in your experience with lay judges versus attorney judges and their perspective on judging.
I can go if you want me to.
Sure. Well, we can do it backwards. So, Judge Garrett, please go first.
Okay. One thing, of course, lay judges, they have to sit in a panel of 2 out of 3. That might be an issue, especially in, you have in the higher populated jurisdiction, Baltimore City, Baltimore County, Prince George's County, even Anne Arundel County that is growing, in Charles County, which has grown tremendously. So, but lay judges, they are very versed in the areas they are used to, the issues that might come up, and when there's a pure legal issue. And because I have practiced law in so many areas, you have family law issues that come up, you have contract issues, bankruptcy issues, they all come up in estates matter. One thing I have to mention, we have to be doing kind of a good job, because the trust attorney, they want us to handle many things here. And guardianship, we used to handle more expansive guardianship matters, but the attorney general issue of opinion, as you probably know, a decade or so ago, they limited the areas we can go into. But I'm going to try to keep it short. I could go on and on, but let me just stop at this juncture.
Thank you, Your Honor. Ms. Burrell-Rody, same question.
Hi. So my experience is that it's really varied. Not all lay judges are as dedicated as Judge Bright or other lay judges. But at the same point, I do think there's like a sense of familiarity and there's less black robe syndrome, maybe. I don't know for sure, but my experience is it's kind of varied. And I do want to say I get along really well with my court, and we disagree sometimes, have a professional disagreement, and then move on. I've got a very good working relationship with my court. But my other experience really was I would get a lot of questions about trial management and hearsay exceptions, rules of evidence. Those sorts of things were quite a challenge.
Thank you. Mr. Manners, same question.
Yes, thank you. The experience I've had is somewhat similar. The lay judges have varied in their degree of education and skills. The attorney judges have also varied in their education and skills. I'm fortunate enough to currently be working with an attorney judge who is exemplary in most circumstances, and I have absolutely nothing but fondness for him. The idea of going ahead and getting a circuit court judge to oversee this is simply an additional level of education and experience that, for whatever reason, the attorney judges simply don't seem to have. Thank you.
Thank you. And it looks like Ms. Fitch may.
She lost power briefly. She's back in the waiting room, Joe. She just texted and asked if you could add her back.
Okay.
I think I found her.
Okay, thanks.
Ms. Fitch, can you hear me?
Yes, Mr. Lasley, I can hear you. I apologize. My power went out and it came
Oh,
back
good.
on, but the internet did not. So I have missed
Okay.
a few minutes.
All right. Did you hear my question or not?
I did not. I'm very sorry.
So I'm just asking the every panel member the same question of your perspective on dealing with lay judges versus attorney judges and how they approach judging.
As a practitioner?
Well, both as a practitioner and while you were on the court, because I know you served with at least one lay judge.
I did. I don't know that it's necessary to, kind of go through the litany of faults that, certain lay judges may have. Especially for my court, it's kind of water under the bridge. But I just think in 2025, when, like the Honorable, the Register from Baltimore County was saying that, we're not talking about just one 3-credit trust and estates course that's necessary to prepare somebody to take the bench. We're talking about, 2 semesters of con law, which is a 4-credit class, a semester of property, which is another 4-credit class. It's 12 credits there. Evidence, which is another 4 credits. Civil procedure, just understanding the rules and the lay of the land that we're operating in. How to draw a family tree. There's a lot of stuff that's can be picked up by a layperson. And there is, 12 hours is very minimal, but there are really good classes at the Judicial College. But I think those classes, it's my understanding that instructors at those classes are told to teach as if no one's ever heard anything about anything that they have to say. And so it's too little for the attorney judges, and it's still too challenging for most of the lay judges. And I watched, as I was a student in those classes, the polls that were taken and the results that were published, and the rate at which questions were answered accurately after an in-depth substantive review of one specific topic was very disappointing to me. I hope that's helpful.
That's very helpful. Thank you very much. Thank you, Mr. Chair. That concludes my questions.
All right, thank you, Mr. Lashley. Mr. McFarland?
Yeah, thank you, Mr. Chairman. If I could just make a request that before we get to the next panel, if you could repeat some of the good of the order comments that you made earlier. We didn't even get a minute into our hearing before someone felt the need to make personal attacks on the registers. So if we could get past that, we only have 2.5 hours left in our task force work, and it's a distraction, and it's unprofessional, and it's really unnecessary. Now, I have a question for Mr. Manners, and I know you've been watching these meetings, and there is this equivalence that we have heard between, well, as long as you're an attorney, you can handle probate matters, versus what you just talked about a few minutes ago, which was everything all the bells and whistles that come with a circuit court judge. Not only that they have a law degree and passed the bar, but that they have practiced law for usually decades, that they've been through a thorough vetting process, that they're trained on temperament. And I'd like you, on that last point in particular, since you've served under so many courts, if you could talk about your perspective on whether, the bare minimum of just having a law degree versus all of the expertise and experience and training on not just the law, but how to be a judge that comes with a circuit court judge.
Certainly. Thank you for the question. The long and the short of it is that the attorney judges that I've been exposed to have varied widely. One is our current chief judge, and he is a stellar gentleman. Another was unfortunately removed by judicial disabilities. So the temperament varies widely among any class you'd care to mention. The benefit that I've had working in the courthouse has been that when the judges in the circuit court have issues in front of them involving probate matters, they contact me and they ask me questions and pick my brain and just what you would expect with that. And they grasp the issues quickly. They understand the important parts. They can dispense with the unimportant parts. And in bearing and demeanor, they generally have the gravitas that accompanies the title of judge. And that's not an unimportant thing. I think a lot of times people, rightly or wrongly, disdain lay judges or attorney judges as being less than, and they're not necessarily less than, they're just different from. The circuit court judges with whom I do a significant amount of conversation are all very well educated, very eloquent, very reasonable people, and they are a positive attribute to the judiciary.
All right, thank you very much.
All right. Mr. McFarland, do you have any other questions?
Yeah, that was all. Thank you, Mr. Chairman.
Okay, yeah, I'm just trying to give you the same courtesy. Everybody asked about 3 different people, so. All right, Judge Fisher?
Thank you, Chair. Let me lower my hand. It's nice to see some of my colleagues, some of my favorite colleagues on here. My favorite colleague is our Register of Wills, Alexis Burrell-Rody. I know that I just want to say, I know there's been a lot of talk about animosity between the registers and the Orphans Court. And I feel very lucky, and I think that she does too, how well we function. So one question that keeps being raised is the registers being asked to provide legal advice, have hand-holding by the registers and drafting orders by the registers. Do you think in a court where you have experienced attorney judges that you see any of that need? And do you think that an attorney judge court can function as well as a circuit court with respect to fiduciary matters?
But to me,
Yeah, you.
Judge. So I think the big thing about why, I mean, in my office, we've never been called on to prep a case or draft an order. But I think that is maybe a product of actually Baltimore County Orphans Court has a staff who can do those things for them. So I have about 38 employees, and 2 deal with the court. By statute, someone from my office sits in on all court proceedings, but we have never been asked to draft orders or prep cases or give. Sometimes as colleagues, we discuss legal issues about estates, but it's not a because the judge doesn't know, it's because it's a tricky issue, and there are tricky issues sometimes that come up in court matters. So I do think it would be great to have the Orphans Court vetted with a judicial nominating committee similar to the circuit court. Have mandatory retirement ages, not do de novo appeals. I'm trying to squeeze in all the things that I wanted to say before that didn't have time. But I do think if a court was trained and took judicial education and had estates and trusts, that I maybe lost track of your question. Would attorney judges be able to draft their own orders? And I believe, yes, that would be definitely something they would be able and capable of doing.
Okay. I'm going to move on to someone else just so I talked to a couple people. Judge Garrett, thank you for being here today. I know you spoke some about you believe that you think attorney judges might be more appropriate statewide for the Orphans Court. Do you think it's still important to have a separate probate fiduciary court, and why? You're muted. You're muted, Judge Garrett.
Judge Garrett, you're still.
Okay, can you hear me? Can you hear me now? Okay. Sound like Verizon. Can you? But in any event, I think it is important to have attorneys hear things. As I mentioned, I'm a practicing attorney also, and before I even graduated from law school in 1978, Mrs. Juanita Mitchell, she that her husband, one of the courthouses in Baltimore City is named after. She had an extensive estate practice. Of course, me being the younger attorney, I usually handle most of those things. But one thing and as was stated by a few other panelists, they stated that property law, and I mentioned this previously, property law, family law, and different areas come into play when you are trying to make a decision. You need to know something about those areas. Now, I would say that if we have, one thing that I alluded to is that I know a lot of trust attorneys want to come here, want a fiduciary court, because a lot of the circuit court judges aren't familiar with a lot of the trusts, and they rotate. And in the Fiduciary Court, of course, hopefully we will focus just on that. But you have people in juvenile court that rotates in and out, criminal court, and I don't have to name the other areas. So I do think that it would be helpful to have attorneys. Again, I don't want this, because there are so many good lay judges, but when you look at the complexity of cases that come, many times, I know Mr. Mark Wasner, he gets calls, I believe, when there's issues that might have to get a legal opinion, but that's something that comes very natural to if you handle cases. And by the way, a lot of circuit court judges, they may not have decades of experience, and then a lot of them have a limited practice, and there's a learning curve for them to really absorb all the matters and the different type of matters that do come in front of them. I lived through about 4 generations of circuit court judges at this time. So I have seen, the training, that learning curve take effect. But in summary, I would just say, yes, it would be helpful to have lawyers, a Fiduciary court, if they do come into being, that you would focus on that. So many of the issues, especially in trust, guardianship, I had done many guardianships over in my career, but that's a very tedious area, and you can't make mistakes in those. So yes, Judge Fisher, who I know is very versed too, that yes, I think it would be very helpful.
Okay, so my last question is going to go to Ms. Fitch, who I should say Judge Fitch, because she was a judge, and so you're always a judge once you're a judge. You heard what Judge Garrett said, and as a practitioner, I think I'm asking you more. Do you think, in your experience as a practitioner, that having a separate fiduciary court would be better for the citizens of Maryland? And as a secondary of that is, do you see in places like Montgomery County, where you have 22 circuit court judges each sitting a week or two, and maybe with zero experience in fiduciary matters, that being a concern?
I think that specialty courts are great, whether it's a fiduciary court, a family law court. Our circuit courts really, they have jurisdiction over criminal matters. Are people going to prison? Are they going to jail? Are they going to be separated from and then they have jurisdiction over custody. Those are really, really heavy decisions that kind of puts their trust and estates and fiduciary training like on the back burner, so to speak. Like they only have so many hours to go down to Annapolis every year and learn all the latest and greatest laws about different subject areas. So I think that having judges that just sit as fiduciary judges would be excellent because, like we were talking about before, it would allow them to really become experts. I agree with Judge Garrett and everybody else that those judges should be attorneys. I don't see any reason why the jurisdiction of the existing orphans court couldn't be expanded to include guardianships and trusts and other fiduciary matters. We already have the framework in place, and this task force has kind of highlighted the need to fully staff those courts. It's not really the registrar's job to help the orphans court judges make copies or pull a case or pull a statute. The judges should have their own staff for that.
And so just to follow up, the way that your suggestion would be to maintain some structure of the current orphans court system, expand the jurisdiction, and you're suggesting make attorney judges and maybe some other recommendations with respect to education or training in those areas?
In my dream world, I know this isn't the most important thing to everybody in Maryland, but it is the most important thing to me professionally is just we have so many resources in Maryland to build the best fiduciary court that this country has ever seen. And I would hate to see us not use those resources and accomplish that goal.
Thank you. All right. Thank you, Senator Charles. I think I've probably used up more than my 2 minutes.
I was on mute. Finally, Judge Groves. And then after Judge Groves asks her questions, we're going to go on to panel 2.
Thank you, Mr. Chair. My question is for Judge Garrett. Judge Garrett, as a judge in a large jurisdiction as I am, I have spoken with people in the clerk's office, the circuit court clerk's office, and circuit court judges. They do not want to absorb our caseload in the orphans court, and they're very adamant that they would like our court to remain separate. They just couldn't handle it. I wanted to know if you've spoken with anyone in Baltimore City in the circuit court or the circuit court clerk's office with respect to the possibility of their absorbing your caseload, and what do they think about that?
I have not spoken to anyone in the circuit court, but I can tell you what happens because, again, I practice law. I mentioned we have about 1,400 hearings, just hearings a year, and not mentioning the other types of orders that come up in our court. For the circuit court, again, we have about 35 circuit court judges here, and those judges, they have, I'm not going to say a backlog, but they are, what we can do in the orphans court, it takes the circuit court much longer to do. On guardianships, I mentioned guardianship. Before the Attorney General and authority was limited in guardianship, a lot of lawyers like to come to the circuit court because they could get guardianship in place in a couple of months, whereas it may take 6 months to 9 months in the circuit court to do it. Judge Fisher, and she mentioned that it would be nice to have people who are trained in that area. And I agree totally, but I don't think the circuit court could absorb. They probably have to have about 5 more judges, the number of cases that we handle each year. Now, I have some recommendation of some of the judicial protocols that should be given to orphans court judges that we are overlooked many times. So, but I do answer just very shortly your question. The circuit court, I do not think could take all the hearings with all of the other outstanding matters they handle and do it within the time period we do it. And as the old saying goes, justice delayed is justice denied.
Thank you, Judge.
All right. Thank you. I'd like to thank you, Ms. Fitch, Mr. Manners, Ms. Rhodey, and Judge Garrett for taking time to be a part of our very first panel. We've got a lot of information, and we truly appreciate you guys participating in this process. We're going to, you guys are going to exit out soon, and then we're going to bring in our second panel. And our second panel is Mr. Greg Staub, Judge Edward Crossland, Catherine Hager, Judge Melissa Bright, and J.H. Snyder. And Holly, if you can let me know once we have everybody in.
They're here.
Everybody's in? Okay, thank you guys so much. If you please make sure that your Zoom name represents your first and last name and the organization that you represent. If you are on YouTube, please exit out because it gives feedback, and the first panel had someone who had feedback on here for us. If you are driving, please stop driving, pull over, and handle this while you're not driving. We do not want you to harm anyone on the road or be unsafe for yourself Additionally, we're going to ask that everybody keep their 2 minutes, and it's a limited amount of time. So 2 minutes, keep it straight to the point on the issue, where you stand with this particular issue based off of the piece of legislation that was passed. And then from there, please keep any negative remarks about any of the organizations, keep those to yourself, and just be very specific to the actual legislation and your feedback. So we are now going to jumpstart everything. And we're going to start with you, Mr. Greg Staub.
Thank you, Senator Charles, and members of this task force for this opportunity. My name is Greg Staub. I live in Anne Arundel County. I'm an IT manager for the Registers of Wills, but I'm here speaking for myself only. For 18 years, I've worked for multiple Registers of Wills. I develop our case management software. My job is to know everything about the statutory authority of the Registers of Wills offices and apply them to our workflow. I've observed the orphans courts directly, specifically non-attorney panels and circuit courts sitting as orphans courts. I've held discussions with full attorney model judges in different jurisdictions. I've watched this task force because my livelihood depends on it. These are my very incomplete observations. The 9 marching orders were not fully addressed or approved. This task force must be extended to give usable recommendations, especially about expanding the orphans court jurisdiction to hear more fiduciary matters and the related qualifications for hearing them. It is illogical to recommend reforms where non-attorney judges would expand jurisdiction for matters currently requiring attorney judges, especially guardianships and trusts that require resources beyond an orphans court's means. This reduces the quality of justice at the expense of the citizens. Why continue having partisan elections for 3 judges where there's proof of success, and in large jurisdictions with existing resources with 1 judge sitting and rotating? A magistrate is better suited to bench work, which is the vast majority of orders signed by orphans courts. Because magistrates are mostly attorneys, a judge should also be an attorney and be used exclusively to settle disputes. Task force keeps suggesting regional judges, but this must be avoided. Citizens deserve daily or weekly justice from peers. Regional judges cannot be everywhere and would paralyze probate. Recommendations requiring transferring clerk or register employees are impossible because they don't fall under the same employment authority. These staff members are not portable even with major reforms. Recommendations about the clerks or registers also exceed the scope of this task force. In conclusion, I ask the task force recommend more task forcing. Because I'm a problem solver and have knowledge of the system, I believe the best and least expensive solution. Can I finish?
Yeah.
Okay, the best and most inexpensive solution is to allow magistrates to handle bench work while expanding jurisdiction for 1 attorney judge, elected or circuit court, to hear non-probate, death-adjacent matters, but giving all guardianships to circuit court. Thanks to everyone. Thanks to Joe and Holly, especially staff member to staff member.
All right. Thank you, Mr. Staub. Judge Crossland.
Camera's not on.
Judge Crossland, can you come on camera, please? Mr. Crossland, Judge Crossland. All right, sounds like Judge Crossland's having some technical difficulties. While he's getting himself together, we're going to move forward with Catherine Hager.
Good evening, and thank you, Mr. Chairman and members of the task force, for letting me speak this evening. My name is Catherine Hager, and I'm the clerk of the Circuit Court for Queen Anne's County. And I'm speaking this evening based on my 20 years experience working in a small jurisdiction known as a one-judge county, and not on behalf of the Maryland Judiciary. I simply want to ensure the citizens continue to receive timely service and without confusion if the judges of orphans court work is transferred to the Circuit Court, while the Register of Wills office remains in a separate location. Based on the data provided in this task force, it is difficult to understand the true impact this may have on a one-judge circuit court versus circuit courts that have multiple judges that can share responsibility of cases with their colleagues. as discussions over the last few weeks with this task force has been with larger jurisdictions. In this one judge county, the circuit court manages a tremendous workload ruling on motions, emergencies, addressing DV petitions, signing search warrants, conducting daily bail reviews, approving recommendations from the magistrate on domestic and juvenile matters, and the judge also provides over all the criminal, civil, and family law dockets, including the jury trials, while fulfilling administrative responsibilities as county administrative judge and overseeing the problem-solving court of drug court. Adding orphans court responsibilities on top of the duties of a one-judge county, especially in this county with a growing senior population according to census data, would significantly increase the burden of our single judge and potentially slow the resolution of orphan court cases. My last point is in Queen Anne's County, our Register of Wills and Orphans Court is not located in the new Circuit Court building, nor is there room for the Register of Wills in this new county courthouse. I would envision it may be difficult for staff to coordinate services across two locations when both the Register of Wills and Circuit Court uses two different case management systems. Therefore, the technology needs of integrating multiple systems should possibly be considered in any analysis and recommendation. Thank you for the opportunity to testify.
John.
Thank you. Thank you. Next, I see Judge Crossland. He has his camera up and we can't hear you though.
Can you hear me now?
Yes, sir.
Okay, thank you. Yes, I apologize for that. My name's Ed Crossland. I'm judge of the Orphans Court in Allegheny County. I've served since 2014. I've also been assigned to Garrett County on 4 separate occasions. I am also a member of the Maryland State Bar. I'm very concerned about the ability of the rural counties to be able to staff any potential orphans courts solely with attorneys. I am the only attorney that has served on our orphans court in Allegheny County, at least for 60 years to my knowledge. In Garrett County, there was a retired district court judge who had passed away. The newly appointed judge is a member of the Maryland Bar, but he is retired. I would ask that the task force be extended to continue to serve, or to continue to investigate and determine what is best for the rural counties, particularly here in Western Maryland, where we do not have a lot of attorneys. I would also indicate that from the perspective as things are now, I have an excellent working relationship with our Register of Wills, Mary Beth Perlazzi. I have an excellent relationship with the Register of Wills in Garrett County, Rita Watson. Both are superb. I think that they have a good relationship with the court. We work well together, and we have had no issues that seem to have plagued some of the other counties that have brought this matter to the forefront that resulted in this task force. But I do believe that if this task force does desire to make substantial changes, that it be extended for some period of time to determine just what is best for these rural counties of Western Maryland and the Eastern Shore.
All right, thank you, Judge.
Thank you.
Next, we're going to have Mr. J.H. Schneider. And it looks like Judge Bright may not be joining us. She submitted written testimony.
Can you hear me?
Mr.
Yes.
Schneider, we can hear you loud and clear.
Thank you. I am speaking as a member of the general public. My testimony concerns Task Force Goals 3 and 9 concerning the efficiency and quality of fiduciary adjudication in Maryland. My overall take is highly critical of Maryland's system of fiduciary adjudication. I believe it has a political dynamic akin to what led Charles Dickens, the published Bleak House, Sam Islands 75 years ago. I doubt the task force would disagree that its overall goal is more efficient and effective justice in keeping with fiduciary ideals. The problem is implementing that goal by prioritizing the interests of the professionals involved of the system, while turning a blind eye to the harm that does to the family system is supposed to starve It would be wonderful if those interests weren't in conflict. Alas, despite the few protestations to the contrary, they have been in terrible conflict, albeit in countless little details that goes on to the fog and Bleak House's opening scene. I hope Maryland will not move in the direction of Massachusetts, which granted the legal profession much more control of the probate process, despite the wonderful public spirit rhetoric associated with that long-term transition. It has been a disaster for the public. Giving respect and power to experts is much to be applauded, but not when those experts can and have a track record of using that power and versus significant parts of the population they were supposed to serve. Much of the problem may be not intuitive to you. For example, the lack of litigation in this system may signal profound corruption in this system, rather than a system working well.
Mr. Snyder?
Yes,
Yep,
I'll
we,
close.
I'll give you 5 seconds to close.
Letting a truly public spirited former Jenner would require far more time than I'd be given. I'll just mention one. The priority should be to proactively empower families, as opposed to spawning their conflicts after they arise. This system is woefully deficient in that regard.
Thank you, Mr.
And I have other submitted as public witness testimony. Thank you.
Sir. And we truly appreciate you submitting a written testimony as well, so that each member will get the opportunity to read through if they have not already. I'm going to ask that everyone who has questions, please utilize the raise your hand tool, and we will go in order of what I see. And so right now we have Judge Fisher, then Mr. McFarland. So Judge Fisher, go ahead and start with your questions.
Thank you, Senator. Judge Crossland, nice to see you. You were mentioning the difficulty in the number of attorneys. I know that you and I've discussed previously, I think in Garrett County, there's maybe like 8 members of the bar, and one's a circuit court judge and a district court judge and a magistrate, and one's the public defender and one's the state's attorney. So that leaves a small amount of even practicing attorneys, let alone attorneys available for orphans courts. Do you think that it could be practical in smaller jurisdictions to have one attorney similar to the larger jurisdictions who could sit independently? Do you think that's a system that could work in the rural western counties?
You mean like one judge for several counties?
Or even, I mean, some of these are the recommendations I was hoping we'd get to in this task force, but either one judge in, if you've sat in Allegheny and Garrett, or one judge in each of those counties. I'm not sure what you think might be better, since you're the one who has experience with those jurisdictions.
I think you may have difficulty getting one attorney to serve as a judge. I make my salary's public record. It's like I don't think I make $8,000 a year sitting as a judge. And frankly, I think you're going to have a difficult time getting a member of the bar to sit without a substantial increase. And these salaries are funded by the counties. And so I think it's problematic in that standpoint that you're going to be able to even find somebody. Now, perhaps if you combine a couple rural counties, and I don't know how that works constitutionally at some point, but for instance, for districts or circuits, excuse me, my apologies, circuits, that might be workable, but I think it's going to be difficult. It would be difficult here, even in Allegheny County. The one thing I would mention to the task force is this. Out of the last task force to study the orphans court came the recommendation to allow attorneys in these smaller jurisdictions to sit as an orphans court judge and practice law, so long as it does not interfere or conflict with their role as a judge, and there's been rules promulgated to that effect. Certainly for somebody like me that litigates some cases, that is beneficial. And I think this will be the first election cycle where that ban on the practice of law statewide has been lifted. And we're coming up into an election year. I know I'm getting ready to refile. This will be my fourth term. And I think that perhaps we should give that an opportunity. If one of the concerns is to have folks who are attorneys with more legal knowledge on the court, let's give this election cycle a chance to see if it actually does result in more attorneys seeking a seat on the orphans court. Again, that may be problematic with the salary. Now, we do get benefits, and for somebody self-employed as myself, the health insurance benefits are in a bit of a retirement, are somewhat significant and attractive, and perhaps that could be attractive to an attorney in a small practice. But you get in a small jurisdiction, and estate work makes up a substantial portion of a lot of the attorneys' practices, and they simply can't give that up.
So you think if the salary was commensurate with the responsibilities, especially if there was an increased increased non-probate and other trusts and matters, that you maybe would be able to find someone either for several jurisdictions or each jurisdiction?
I would anticipate that would be correct.
Okay.
The correct assumption.
And then I have a question for Ms. Hager. Is it Hager?
Yes, Hager, like
Thank
Hagerstown.
Thank you for your time. I know we've met some of your orphans court judges or our colleagues on the conference. So because I'm in a larger jurisdiction, that's why I want to make sure I understand. And I've talked to some of our colleagues in smaller jurisdictions. So you think that adding the additional amount of orphans court work would not only potentially overwhelm what sounds like the already very overwhelmed circuit court, but also perhaps delay the ability to conduct timely hearings in both the circuit and the orphans court?
Yeah, so I guess my thoughts with that is we do already have a one judge county in Queen Anne's County, which is already task full. Her docket is completely full. And what I hear from the orphans court and from the citizens in the county when I'm out and about, because they sometimes confuse me with the Register of Wills, is what a wonderful office the Register of Wills and the judges of the orphans court do in handling their matter so quickly. So I hear lots of compliments on that office and the orphans court and how quick they are to respond to cases. I just don't know, by looking at the data that was presented, how we can determine how much more work will be put on a one judge county in addition to the already workload that they already have. And then of course, in getting new judgeship, it's kind of difficult at times. It's a big process to go through and getting new circuit court judgeships.
So yeah, I guess to follow up something I heard you say, which I thought about recently too, is that there aren't a lot of people who are attending these meetings who are complaining in the rural jurisdictions about the quality of judges that they have. We're not hearing from members of the public who are saying that they're unhappy with the system. And do you think that perhaps it's something that maybe right now it's more of a county by county, what works for each county system? And I know we're talking about uniformity, but uniformity between Queen Anne's and Baltimore County may be a really hard thing to put into place because of the different sizes and needs of each of the jurisdictions. Do you think there is some benefit to having these separate systems in place for the different jurisdictions?
I do see some benefit of that, being different. But I know it is a goal to always have uniformity in the state. It works better that way at times. But I got on here today just to express from a one judge jurisdiction what the caseload would be if the orphans court processes were over to circuit court. I will say, and because I only had 2 minutes of time, it's hard to put a lot in there, but I have been with the judiciary for over 30 years. I started in Baltimore County Circuit Court in the early 90s. I was in Howard County for 10 years, Howard County Circuit Court, and ended there as chief deputy clerk before coming over to the Eastern Shore. So I've seen how the different jurisdictions work as far as the caseload with judges and the sharing of duties, but seeing it firsthand for 20 years as a circuit, as one single judge, it's just, it's a lot on the judge. But that's, I don't, other than that, I don't have much to say about how it should work in the future. I really think this task force is excellent. I've listened to the meetings over the time, and I just think it's doing an excellent job and really thinking of all the different options that are out there. Just
Thank you. Thank you for giving that perspective, because it's definitely different. I appreciate it. I think that's all, Senator Charles. Thank you.
No problem. Thank you, Judge Fisher. Mr. McFarland?
Yeah, thank you, Mr. Chairman. And thank you for all the panelists. This has been really, I've been very interested to hear what all of you have to say. Mr. Snyder, it's good to see you. Judge Crossland, thank you for being here. We've been hoping to hear a little bit more of the perspective from smaller jurisdictions through this process, and I appreciate you being here and sharing your perspective. And for Mary and I, tell Mary Beth we say hello, and we'll see her soon, I'm sure. And so my question for Ms. Hager, I'm sorry Howard County had to lose you, but anyway, can you remind me, how long have you been with the clerk's office in Queen Anne's County?
2006, so going on 20 years in a few more months.
So one of the things I'm curious about, is, this is a completely open-ended question, and I would value your insight. I've looked at some of the statistical reports put out by the judiciary about the caseload in the circuit courts. And just for Queen Anne's County, for example, in fiscal 2018, there were 2,337 new proceedings filed in the circuit court. In fiscal 24, it was 1,763. So the number of, and that trend is statewide, that the number of cases we have is actually going down slightly. Can you give any kind of insight into why you think that may be?
No, I can't. I would have to look at the numbers and see exactly which case type is going up and what's going down. There was a period of time, in 2020, 21, 22, foreclosures went down because people weren't filing foreclosure cases. So no, I would have to really look into to see the difference of that. But I will just mention real fast about looking at numbers in the new case filings. With a single judge county, that doesn't also represent everything that judge is doing because of all the post-judgment motions, the reopenings being filed for modifications of child custody, child support, and so forth that's happening. Plus, of course, we have I don't know how many exactly guardianship cases that we currently have, but we call them the continuing trust cases where they're reviewed once a year. So it's, I guess what I'm trying to say is all the other post-judgment items that go into also the circuit courts, not just the new case filings.
Okay.
The caseload is very heavy with the reopenings.
I appreciate that. I think that was all I had for you. So thank you. And the last, and I'll just add, the registers and orphans courts saw a significant uptick in cases in 2001 and 2022. That was sort of post-COVID. We just frankly had more, very tragically had more people passing away than we ordinarily would. So the last question I had was for Mr. Staub. So one of the issues, and I hear it floating around as something that I guess some people are entertaining that we would continue, which is the 3-judge panel for the orphans court. As you know, or as those of us in this task force know, we are the only state in the country that has 3-judge panels to handle probate or any other kind of fiduciary matter. With your experience seeing when you were in Anne Arundel County, different makeups of courts. And as you have traveled the state as one of our IT specialists and you have interacted with 3 judge panels, can you offer any kind of commentary on whether you think that, we just heard, for example, in Allegheny County, maybe we can't find 3 lawyers, but maybe we can find 1 and raise the salary so that it's worth it for them. I think there's a lot of merit to that. But the idea that we would statewide continue to have 3 judge panels as the only state in the country that does that, how do you see that affecting? And we're talking about uniform application of justice. We're talking about efficiency. We're talking about cost. How do you see that? What's your take on that?
Thank you, Register, for the question. My take on that is that 3 judges often have 3 opinions. And I experienced that a number of times when I was, I guess I was a chief deputy in Anne Arundel County, and I had to deal with a lot of the personalities in the office. And when you have the 3 people, all with 3 different opinions, all sitting on the same panel, it creates a lot of conflict. And that can often lead to the absence of justice. Another thing, too, is that all of these jurisdictions, these rural jurisdictions, do have at least 1 orphans court judge. And I do believe that that 1 orphans court judge could hear all of the cases if their schedule was changed, if their salary was changed, so on and so forth, where they could, at least with the help of like maybe a magistrate or some sort of staff, be able to kind of divide and conquer to be able to handle a lot of the desk work versus the actual adjudication that happens. A lot of the I guess, workload, I hesitate to use that word because of the terms of the task force, but a lot of the work that orphans court judges do is chambers work. It is desk work. They return a lot of orders, and it is a substantial amount of work. And I think that there could be stratification with, something like a magistrate or, some sort of a legal assistant or something reviewing the desk work and making recommendations to a judge so that the judge can actually utilize to focus on just adjudicating, settling disputes, things of that nature. And with subtracting 2 of the judges and adding their salaries to the 1 judge, it doesn't even matter if they're an elected orphans court judge or if they're a circuit court judge. That 1 judge could adjudicate those matters in those jurisdictions. And somebody, whether it be, circuit court staff, a magistrate, that's bigger than me. That's bigger than me. Those people could assist with making recommendations to that judge to really kind of like prop up this practice, and it would eliminate a lot of the, I guess, difference of opinion and consternation that some orphans courts do have.
Okay, well, thank you. Thank all of you. Really appreciate all your time tonight. That's all I have, Mr. Chairman. Thank you.
All right. Thank you, Mr. McFarland. And thank you to you, Mr. Greg Staub, Judge Crossland, Ms. Catherine Hager, and Mr. J.H. Schneider. Thank you guys for coming out and participating in this process. We truly, truly appreciate you. We're going to move on to our next topic on our agenda for today, which is continued from last Monday's meeting, which is the preliminary fiscal information of fiduciary adjudication scenarios related to structural changes in the current court system. And so we had questions left over from Joe, Mr. Lashley, and Monica Mitchell. So Joe, do you want to go ahead and kick this off?
Yes, sir. Thank you, Mr. Chair. I'm not going to go through, spend a lot of time on the slides. I hope you had a chance to look this over. And again, as I mentioned, these are just scenarios to give a range of the magnitude of the costs that could be involved in some of these structural changes. And there's 4 scenarios here. And I'll just mention the titles and you can look at this. They all have it's not really a fiscal estimate, it's just a fiscal effect. That one was the orphan court judges would be full-time attorneys and they would have expanded jurisdiction, including fiduciary matters. And so you can look at the low cost, medium cost, and high cost example there. The second.
Can I ask you one question?
Yes.
I just want to make sure I understand. So in your examples, we're still having a separate system for Howard, Harford, and Montgomery County? Or is this including having one uniform system for the whole state? And they would then have an orphans court back, but in the same context as the other jurisdictions?
They would still sit as the orphans court, and the circuit court judges would still sit as the orphans court in those 3 counties, but they would have expanded jurisdiction for all fiduciary matters.
So do we have
like
any
the other orphans courts?
Do we have any numbers where we put them back into the pool? Because I think a lot of what we've been talking about was uniformity throughout the state. And if we still end up with 2 systems, that doesn't seem like that's, I know that's not something that I would want to see, is multiple. So we don't have any proposals where that's the case, where they're brought back into the pot.
No, this is, I mean, the jurisdiction's uniform across all the counties, across all the orphans courts. It's just, we accepted them in saying that they wouldn't have any additional costs because they're already handling, the circuit courts are handling probate and non-probate matters. We're just saying that the judges that sit as circuit court judges as the orphans court would now have the expanded jurisdiction. So the jurisdiction's uniform across the state. There's still the orphans courts. There's still circuit court judges sitting as the orphans court, but we're not taking them out of the circuit court, if you will. Is that
Judge Fisher? I believe that the scenario that you're talking about is the next slide.
Okay.
So maybe if we want to go through the scenarios first.
Okay.
Yeah, I was just getting a little confused about exactly, I mean, I know we were talking about having one, I mean, well, there's lots of different thoughts, obviously, but one of the options was having each jurisdiction have the same thing, which would be a separate, distinct court and not
right
as orphans court.
No, this, this, go ahead, Jonathan.
Yeah, I just wanted to say, please bear in mind, everybody, these are just meant to show a range of options. They're not meant to be a menu.
Okay.
They're just say, okay, if you mix and match this way, this is how much it might cost, that kind of thing. It's not in any way a suggestion.
Yeah. So this one, it does not change the 3 counts, just expands their jurisdiction. This is the more the regional judicial circuit option. There's one of these for the circuit courts, and this is for the orphans court, that they would sit, an orphans court judge would sit in every one of the 8 judicial circuits with magistrate judges in each county that would do, the uncontested type matters and routine work.
Is it okay for me to just chime in one more thing? I don't want to overstep, but when we're talking about routine uncontested work, a lot of the motions work that we do is extremely complicated. You could be talking about discovery disputes or summary judgment motions. These aren't just like checking some boxes, and even accountings, when you have detailed accountings and petitions for counsel fees with pages of timesheets. I just want to make sure that everyone who doesn't practice in the orphans court understands that these routine uncontested matters are not just a matter of someone with someone just said a law assistant going and signing orders or making recommendations as to orders. I think this work is actually really substantive, and I would actually hate for it to be separated out between one person only doing that and one person hearing the cases, because I think part of what makes me better as a judge is having my feet in all of those pots so that I see what's happening with various estates. I might say, oh, I remember in that account, there was that weirdness, and now I have a hearing on it. There's an interconnectedness between this whole system of probate from start to finish, including inventories and accountings and motions and petitions that are all really related. So this segregating them out in this fashion, I think as a practical matter for someone who does this every day, doesn't really seem to make a lot of sense to me.
Okay. Well, I appreciate that, Judge Fisher. I didn't mean to suggest that this would be a magistrate judge getting a full-time salary and would be an important person. I didn't mean to suggest that uncontested matters are complicated.
Yeah, it wasn't you, Joe. It's just been a
Yeah,
number
okay.
of times
Yeah, I just
people have
wanted
just
you
said,
to-
oh, there's this paperwork, they sign orders.
Right.
It's like, okay, signing orders is actually kind of really important because it changes people's lives depending on if we sign an order in one way or if we make changes to the order, which we do a lot. So I just wanted to clarify for everyone, I think.
Thank you. And then the third, this is very much what currently exists. So the first two are about the orphans court, the caseload shifting to the orphans court from the circuit court. The other two scenarios are the caseload shifting from the orphans court to the circuit court. And this is similar, as I say, circuit court judges handling fiduciary matters within the existing circuit court structure. So this would be all circuit court judges, and, you know, whether they could absorb the caseload or not, of course, is an open question, and just the three different low cost, medium cost, high.
Joe, I see Byron.
Yes.
Mr. Garland has his hand up. Was there a question on one of these slides?
Yes, sir. Just very briefly, Joe, on the scenario number 2, I was curious, is there any precedent for this kind of approach with any other area of law in Maryland? I'm just curious if there's some other kind of something else I'm not aware of that we would be, so that we wouldn't be reinventing the wheel, so to speak.
Well, family law has family law uses magistrates, and I don't know if Jonathan, you want to expand on that, but that is, and it is used in some other states. I think 9 states are legislative librarian Mary Jo saw the magistrate system in 9 states. 8 of those are courts of general jurisdiction. The other one's Connecticut. I'm not sure exactly how they're set up.
Yeah, I think I'm sorry. I think maybe I'll be more specific. The fiduciary matter is being handled within the judicial circuit instead of within the circuit court itself.
Could you ask that again? I'm not sure what you mean.
So if you've got 5 counties in a circuit, all of them would go to the same magistrate or all would go to the same judge. That's what I'm asking. Is it, you know,
they would have, yes, there'd be one judge in the circuit, but each county would have a magistrate judge.
But yeah, and I was just curious if there's any other kind of, you know, subject matter that is treated that way in our court system.
I am not aware of that. I'm not sure about that. I mean, family law uses magistrates, but I'm not aware that they're set up by judicial circuits.
Okay.
Maybe others.
That's fine. I'm just curious. Thank you.
Sure. Okay, so this is similar to what we have now in Harford, Howard, and Montgomery counties. And then the last variation or scenario is adding a magistrate judge to the counties, but having the current, using the regional circuit model with a circuit court judge in the circuits and a magistrate judge in the counties.
Well, and this one creates a new division within the circuit court. So there would be new judges in each circuit at least.
And I'll let Jonathan, because these are Jonathan's ideas. I just wanted to mention here the possibility for counties to use retired senior judges that could absorb some additional work, which would save costs. That's always, that's a possibility. We heard that from Harford County, that you use senior retired judges. And the last slide is just to mention if a fiduciary university was created in the Maryland Judiciary that was similar to the Family Law University, it appears that there wouldn't be significant costs with this because the faculty members volunteer without compensation. And it's just a multi-day annual event. And it appears that the staff members at the courts could probably handle that with existing resources. And I just mentioned Judge McQueen asked a good question, emailed me last week about the fact that with adult guardianship, the guardian of the person, there is a jury trial unless waived. So in any of these, if the orphans court jurisdiction expanded and include the guardianship, they would need power to summon jurors and have jury trials in order for everything to be under one court. That would need to happen probably in the legislation. Are there any other questions?
All right, looks like we don't have any other questions. So we can move on to the next agenda item that we have, which is analyzing the effect of the different qualifications of orphans court judges and related litigation procedures on the uniform application of justice in Maryland. So we're going to ask for all the task force members who want to have something to say, have anything to add. We're going to give you 2 minutes, just like we gave the folks that were on the panel discussions. We're going to be fair across the board. So we're going to start with Judge Groves, then go to Judge Fisher. The same way we have it listed on our agenda. Then Judge Huger, then Mr. Lastly, Ms. Pretriati, Mr. McFarland, Ms. Rowe, Ms. Mitchell, Delegate Bartlett, Delegate Kaufman, Senator West, and then I'll close out. So, Judge Groves, you got 2 minutes.
Thank you, Mr. Chair. I don't think I'll need 2 minutes with respect to commenting on analyzing the effect of the access to justice regarding the different types of systems that there are for the orphans court. I don't think that this task force has vetted that issue enough to comment on that. We haven't had we've only today just had persons who were commenting on what it's like to appear before someone in a rural jurisdiction. I think we need to have more study, more conversation about that before any of us can actually comment on that. I've never sat in a rural jurisdiction. I mean, I sat as a visiting judge in another jurisdiction for 6 months. I wouldn't consider that a rural jurisdiction, although it's smaller than mine. I could probably comment on that, but I really can't give a thoughtful, substantive comment with respect to whether or not citizens who appear before those courts feel like they're not receiving adequate justice.
All right. Thank you, Judge Groves. Judge Fisher?
I concur, as I do most times, with Judge Groves. This task force, this is an entire court system. We have not started having substantive conversations about what these changes would look like for people in different jurisdictions, what might be the best. We were bogged down with data and numbers instead of talking about solutions and how we move forward. Instead of talking about the past, what we should have been doing was talking about the best path forward. I would strongly recommend that this task force make a preliminary report by December and continue the task force until our end date on June 30th to allow everyone to do additional research and come up with solutions and suggestions, which we could share in late April or early May, and then perhaps have another public meeting. And again, have a couple meetings of this when we actually have substantive. I haven't had the chance to absorb this yet, let alone talk to my colleagues in smaller jurisdictions and find out what's really the best option for a court that I care so very much about. Making a rash, quick decision at the end of this task force without adequate study seems like the least way forward to provide justice to the citizens of Maryland.
Thank you, Judge Fisher. Judge McQueen?
Yeah, I also don't have anything to add, maybe for a different reason. I'm a non-voting member and I can, talk about what happens in Montgomery County, but other than that, at least at this time, I'm not here to add anything to this topic.
Thank you, ma'am. Mr. Lastly?
Thank you, Mr. Chairman. I don't disagree with what's been said about not being ready to make formal recommendations yet. However, I would like to briefly address the question that's being posed about the qualifications of the judges and the equal application of justice in Maryland. First off, every judge of the Orphans Court that I have encountered is a dedicated public servant. All of them are giving their all. Not all of them are equally able to meet that goal. That's not just a question of education. It's just as one of the witnesses earlier mentioned, that's sometimes there are other factors involved. With that being said, being a lawyer matters, and the process of going to law school imbues a certain mindset, not beyond just the specific classes we take, that lets somebody serve as a judge. Obviously, if they've been litigators, that's even better, because they know about courtroom decorum and things like that. So I would just close by suggesting that everybody imagine being in front of a court with a highly emotional situation, which is what the matters heard by the Orphans Court are, and finding out you're being heard by somebody who has a high school diploma. Thank you, Mr. Chairman.
All right. Thank you, sir. Ms. Petriotti?
Thank you. It's Preterati, but it's a tough one, so no judgment. I'll just add to what John Lasley said by pointing out that the fact that we have 3 different systems across our state really does result in an inconsistent administration of justice. You should be able to, as an individual, go to any county and have the same process apply, but that is not the case with our current structure. We have a situation right now where the first 2, where there's lay judges and attorney judges, there is the process of transmission of issues. There is the process of de novo appeal. Conversely, in the 3 counties in which we have the circuit court sitting as an orphans court, you have transmission of issues, but you don't have de novo appeal. I think it's important that the individuals that are coming into the various orphans courts across the counties, whether it be rural, whether it be city, whether it be somewhere in between, gets the same experience.
Thank you, ma'am. Preterati?
You got it.
All right. Ms. Roll?
Thank you, Mr. Chairman. I agree with what Judge Grove and what Judge Fish said. All of us agree there is no uniform courts. However, we have not really been able to have a healthy discussion. Again, I think someone else before me mentioned that there has been a lot of statistics, facts, figures presented to us, but there's a lot of work that needs to be done here. Mr. Lasley indicated, we haven't even looked at the qualifications of what an orphans court judge should be. And I think we got to start somewhere, agree with that, and then move on to the next thing. And that is, how do we make these courts uniform? So I would go with what Judge Fisher said, and that we do give our preliminary report, and then we keep working as a task force to keep going through this over and over, because as members, some members really don't know anything about orphans court. And this more you learn, the more you become familiar with it, you more understand, and then we can come together as a group and start having some very good conversations. Thank you.
All right, thank you, Ms. Rowe. And I'm sorry I skipped over you, Mr. McFarland.
That's okay, not a problem. I'll agree with, I think, some of the sentiments from some of my colleagues here. As far as, sort of having what we feel like we need to have to be able to make a wise decision, I think there are some data points out there that we still don't know. I think that, looking at, I mean, we do have the fiscal 2024 numbers for cases in the circuit courts. That's helpful to understand the impact on those courts. If we were to move, for example, to the Howard, Harvard, Montgomery model statewide. We need that information. Ms. Prederati and Mr. Lastly, have kind of given a little bit of a side eye to the trust information, the number of trust cases that we got from the judiciary. I understand that's a little more complex. I understand and to some extent agree with the idea of extending the work that we do. I would say though, there is some real low-hanging fruit here that I just, from my perspective, don't like the idea of going into an election year next year, knowing that we could continue to allow the people of Maryland to have an 18-year-old or a 100-year-old with a high school diploma hearing their loved ones' estates through the end of 2030. I really don't like that idea. I think we can see that there is need for reform, whether it's a minimum age, a mandatory retirement age. I almost feel like we should be thinking very seriously about some kind of interim step that we can take as we try to figure out maybe what the final outcome is going to be. And I agree with, with what Kelly said, that, the average person, for those of us that are in this space, we're used to being in courthouses. We're used to being in state houses. It's not an uncomfortable place for us, but we're talking about people who are coming into a courthouse, going into a courtroom, standing in front of someone wearing a robe, holding a gavel, sitting in a chair, where the average person assumes that that person went to law school, that they had substantial experience in practicing law, not just a law degree, but they had some serious, substantial experience. They went through some kind of thorough vetting process before being appointed, before they were given that gavel, before they were given that robe, and before they were put in that chair. And the system that we have now does not give the average person what they expect. And I
Mr.
think that
McFarland?
that was pretty much it. Thank you,
Okay.
Mr. Chairman.
All right, thank you. Ms. Mitchell?
I'm in agreement with most of the comments that have been made. I really appreciated the ability to have perspective from some of the rural judges tonight as well, and hearing those other challenges that to this point I don't think I'd had the full perspective on. I think this is the most complicated onion that has layers, additional layers, I think, every meeting. I am supportive of I appreciated Mr. McFarland's suggestion of a potentially an interim solution that moves us to a more permanent solution. And think that should certainly be considered, just based on the serious nature of this. And then and also that we look at potentially I don't know if it's a June timeframe, but a slightly more extended timeframe than we have right now to be able to deal with this matter.
Thank you, Ms. Mitchell. Delegate Bartlett?
Chair, and there's much that I agree on. There's one thing though I kind of want to get in the weeds on just a little bit. I agree with what Registrar McFarland was saying about and others have said about the attorney requirement. However, my concern is if we did the attorney requirement and tried to make it effective for the next election, there are some folks who might have already filed, and I just, this is a question for our DLS staff. I hate to put this on you, but the question becomes, is this one of those ex post facto laws where, it was fine, it applied to you when you file. Okay, Jonathan has his hand up. I think he might know the answer, but could we change the requirements of someone after filing? That's one. I know we can make an emergency bill and it could be effective, right away. The other thing is, I wanted to just say this because I got it wrong last time, and that is praeterati. So I just had to say that because when I was filling in, I got that wrong. And the other thing is, I found that there was a lot that we agreed on. I do agree that we need to continue the work because it is a bigger project, perhaps than we had imagined. And I think there were areas that we agreed on. There were some things that Holly sent in the working document, the proposals. Some of those I would like to kind of flush out. And I think that they could be, if we can all agree on them, those could be part of our recommendations, and then continue with the task force. I yield my time to Jonathan, if I may.
All right, Jonathan, Mr. Lashley.
Thank you, Mr. Chairman. Thank you, Delegate Bartlett. Just to quickly answer your question, the scenario we're talking about, this would require constitutional change. It happened in Baltimore City when they made the switch from a mixed court to attorneys only. And actually somebody was elected in that election who was not an attorney. They were unable to serve. The person who received the next votes, who was an attorney, was then elected without litigation. Actually, there may have been litigation, but that's what happened.
Wow.
Okay, thank you.
All right, thank you. Delegate Kaufman.
I don't think he's here.
He had to leave early.
Oh yeah, I did see that message. I'm sorry. All right, Senator West.
Thank you, Mr. Chairman. I associate myself with the comments made earlier by Judge Fisher. I don't feel that I am sufficiently conversant with the issues to make key decisions about the future of the orphans courts at this stage. We have agreed on certain minimal things. Some numbers, for example, we agreed on numbers last week. There may be some other things we've agreed on. I think the staff ought to take the next week to draft a brief report. We're required to submit a report, but there's nothing in the requirement that the report has to be complete. So I think we should do the briefest report we can, which encompasses what we have agreed on so far for next week. And I think we don't have to sunset this commission until next July under the existing statute. I think we should keep going beyond the brief report required now. I think the legislators may have a problem being actively involved during the session. But the session ends in, I think it's April 13th, I believe, which gives us the rest of April, May, and June, and July to finish this up. So we can talk about it next week. But my suggestion now is that for next week, our staff prepare the best report they can, given what we've discussed so far.
All right, thank you, Senator West. And I actually agree with you on that. And it's coming from the actual sponsor of the bill. So, we get a double round of applause for him on that. Is there a motion to follow up and do exactly what Senator West, and then we can agree on that and move forward in the next meeting?
Chair Charles, I just have a question about that request because Joe and I and the staffers have to do this. So the plan was to write a report based on recommendations, but we don't really know what those recommendations and proposals are going to be. That working document, we don't know what proposals are coming out or not coming out. So I'm not sure, Senator West, if you want to explain exactly what, with the timing purposes, there's no time to get a report like that together. We were planning to do just a preliminary report based on the
what my idea was. Let's do a preliminary report with the few matters that we have agreed on. That we've agreed on some numbers, for example, and the report would then say that the commission will continue to remain in existence and do its work until sometime next spring, prior to the time when, under the statute, the commission ceases to exist, which I think is the end of July.
June 30th.
The end of June. Okay.
And then next week when we vote on different proposals, are you suggesting then those proposals aren't included in this report? You're voting on just a preliminary action right now, and
Yeah, I'm not sure we're in a position to vote on proposals. But we can discuss that next week. Here's another idea, or a supplemental idea. If members of the commission think we are prepared to vote on specific proposals, why don't you prepare in writing briefly the proposal you think we should vote on and submit it to staff this week so that staff can disseminate it to everybody, so we have it in front of us next Monday when we meet for our final meeting.
Chair, I defer to you, but I think that would be much more helpful for Joe and I, because right now we don't know what to compile because we're not sure what those proposals.
And Holly, I agree. I think that that works. If can everyone have their proposals in by Thursday?
Are we talking about just preliminary proposals, just the things
Preliminary.
that the group has actually agreed to?
Yes.
So we can
And
vote
not
on
something that
next.
we're voting
Or-
on,
or-
substantive changes.
No, the things that we believe we all agreed upon. Some of those things. There was a lot of. If you look at the working document, the proposal, it's quite a few recommendations in there. But if anyone has not submitted those, but I know we have agreed on. Some of us have agreed. A lot of us have agreed on a lot of these things that's on here, but not every single piece of this working document has been agreed upon. So we don't want to move forward without diving deeper into more discussion. So at least some of the smaller pieces, maybe the age requirement, maybe the lawyer piece, but we don't really even know what the lawyer,
Yeah.
the impact on the smaller jurisdictions, right? So
Yeah, that seems problematic given what Judge Crossland said about then wouldn't be 3 judges to seat next year.
I mean, it might be possible to take some of those things and frame them as goals or topics for consideration as we move forward, but not specific recommendations for now.
yeah, but if you send over your whatever recommendations you have to Holly and to Joe, they'll take these things and we'll all take it under consideration on Monday when we bring it for a vote, and we can do an up or down vote because that's what we have to do anyway this coming Monday. We'll do an up and down vote on those pieces and put a preliminary report out. And to your point, Mr. Lastly, just add at the bottom that these are goals that we're looking to address. But there are so many other pieces to this. I didn't really get a chance to say my piece, but I think it's just so much information out here, and it was so good to hear from the smaller jurisdictions to hear the impact. One county has one judge. I don't know how many other jurisdictions we have like that have one judge, and what the impact would be by getting rid of that or making any type of changes, or what happens if there's only one lawyer and that they got one judge. How many lawyers do they have in that county? And the salaries, I've heard some of these salaries, and I can only imagine some of the lawyers who passed the bar, done their due diligence, got out of law school, and not wanting to take that risk of not being able to work in that. But now that that law has passed, the ability for them to at least work in this space gives them some leg room to make money still. So I think we still got a lot of things to discuss surrounding this issue. But with Senator West's recommendations and with a lot of the recommendations that came forward, just having something preliminary so that we can get something out the door. But I doubt very seriously the electeds will have much time during session from January to April. Judge Fisher, did you?
No, I mean, I think the rest of us who can also work during that time, who aren't in session at that point, and talk to some more of our colleagues, and maybe reach out to the judges in the smaller jurisdictions in a more in-depth fashion, and see what they think is feasible in their jurisdictions with respect to whether you could have one attorney judge or. And I do think the point really was again taken from me today, which has been true for most of my career, is that it's not the people in these small jurisdictions that are complaining about their courts. They're just really not. They're, small jurisdictions have a completely different feel about their courts. And so maybe we could have some more testimony in April from some of the smaller jurisdictions and hear some of the thoughts that they have about improving access in their jurisdictions. Because I did think that the clerk of court from Queen Anne's County was really interesting. And I think there are a lot of jurisdictions with one circuit court, one district court, one magistrate. And I don't think it's hard to have recommendations that meet those needs as well as the needs of the citizens in Prince George's and Baltimore County and Baltimore City. It's a hard task. That's why I think we have this bifurcated system that we have. Each jurisdiction's kind of chosen a path forward that works best for their citizens. So when we're considering that, it's something we should probably take into consideration. But I think, Judge Groves and myself can reach out and try and get some more information, and maybe other members of the task force who aren't elected officials in session can work on getting more information and coming up with substantive things. So when we meet at the end of April, we would actually have some really serious substantive recommendations beyond these just, these thoughts that we have on these slides, actually just practical proposals, maybe that we could go more in depth at that point.
Yeah, Judge Fisher, I think that's great if you guys can hold the fort down and definitely get more detailed information during session. I think it'll be very, very critical to get more of our smaller jurisdictions and a lot of our lay judges, because we didn't hear much from our lay judges either, because they're going to be impacted by this. We're making recommendations that may alter that jurisdiction and those people who've been participating and doing this work for such a long time. So I think we need to really bring a lot of folks to the table and get more detailed information. Delegate Bartlett?
I was just going to suggest two quick things. One, if we, I would like the offer to be extended to us while we're in session, so that if we are available, we can attend. That's one. And then the other is, I wanted to know if I would find it helpful, and I think this is what Mr. Snyder was getting at, and that was, he was saying if the families were more educated. I kind of want to, one thing I want to do with this extended time is actually, and I said it before, I actually want to go and see a few hearings in different jurisdictions, because I'd like to experience that and see how the a lay person, not a lay judge, but a lay person, what their experience is before these courts. So that's one thing I just wanted to put out there. And if we had anybody that we could invite, if that is something that would be feasible, that might be helpful.
I can also say, Delegate Bartlett, that not only are you always welcome, any of you in Baltimore County, but that also, if it's helpful, we do have a virtual system set up in place, and I've had other judges who want to observe me on the bench sometimes, that we can just send you the link and we can make sure the virtual system's logged in. I tend to not do virtual hearings except for status conferences or if someone's sick or far away. But we have the ability to allow people to come in and observe court hearings. So, I know I'm sitting 2 weeks in January. I can find those schedules and send them to you and anyone else in the task force. If you're interested, we can set up the link for any of those days or times.
I'm interested. Thank you. That would be perfect.
And I'll be in Anne Arundel tomorrow, Delegate Bartlett, if you want us to the Orbit's Court there.
If I could say something.
Ms. Rowe?
Yes, I think so. What we need to do is to have a plan during the session that this task force doesn't go in 3 or different ways, that we are together as a group, and that we plan this going forward until the session has ended. So I think there has to be some type of plan in place.
Can we talk about that next week?
I think that'd be great, because I want to go home.
Yes, I just want to flag something, Chair Charles, if I could, with that. Joe and I staff a committee, and we have also, I just want to flag that it's very difficult during session, and you have to have a quorum for Open Meetings Act. So if the June 30th does not work, the legislation can be introduced this session to extend this task force even longer. So I just also wanted to flag that that's an option. You are not boxed in with that June 30th after this preliminary report. If next week you choose to extend it into fall, that's an option to have.
All right. All right. Is everybody ready to go home? All signify by saying aye.
Aye.
Unanimous vote.
It's a unanimous vote. Listen, everybody, thank you all for participating in this. We've got a lot of work to do, and we're not all on the same page with everything, but I think we're getting closer and closer to a good recommendation. And so I just want to thank you guys for taking the time. Please get any other recommendations that you would like to see to Joe and to Holly, at least by Thursday, so they can have the proposed working document finalized, so that we can move forward on at least something.
Chair Charles, I'm sorry to interrupt, but if you've already sent me your proposals, could you please just send it again with the idea that this is going to be happening on Monday, and you are definitely going to propose that proposal recommendation for the preliminary report, just so that I'm aware of what I need to pull out of that document and what is no longer necessary.
Ms. Rowe, did you have another question? Okay.
No, sir.
All right. And so our next meeting will be on Monday, December 8th, 2025. Like I said, please get those recommendations out. And once again, thank you all. I am going to call the meeting to a close and wish you guys a good night. And we'll see you on Monday.